are live.
Welcome back to the House Judiciary Committee this Tuesday afternoon, February 24th. We're going to now turn our attention to H 642 involving various changes to our youthful offenders law. And we will start with a walkthrough by our legislative council. I'll just flag one thing, and this probably came a little late in the whole process, but just so in re-reviewing H 721, which not taken up, it also had the sections related to youthful offender. And I have suggested to witnesses that if they want to address not the whole thing, but specifically changes to section 5284, I'm welcome to hear from them on those few changes. I think that it'll come up one way or another anyway, because I think they're those pages are being copied right now, the pages that include the youthful offender. But the focus is really on H 642. Yeah. But I know that the discussion is going to bring in these other ideas, so I just wanted to flag that. But Eric's not doing a walkthrough of that. So
the part you're mentioning
from 785. I'll get it. Section 5284, section 7 specifically. It's page 14. Starts on. It's a few pages. Okay, over to you, Eric. Thank you for being here.
Happy to be here. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough, as the chair said, of H 642 and activating the youthful offender proceedings. I didn't quite follow that first other bill you were referring to. Hopefully that wasn't one of mine that I totally forgot about. But,
no, we thought you were just going to do this, but just in looking again at it's the omnibus public safety bill from the administration.
Oh, right.
21, right. Has youthful offender in there. And whether I said it or not, I'm sure some of the witnesses are going to talk about aspects of that, but I specifically, if they are, would want them to focus on this one section, 5284.
Right.
The other sections, I take a very different approach to youthful offender than what 642 does. So
right, that makes sense.
That was the original was Michelle and Hillary, right? Hillary.
Actually, I have to admit, it was me.
What's
I don't remember the number. Okay, trying to sidestep it that way. So yes, I did do the youthful offender parts of that bill too.
Oh, you did? Okay.
Long time ago. Seems like in legislative time. Long time ago.
I didn't even want through my mind. I had to look. I thought maybe it was Ben who started it. So
right, that's possible.
Yeah.
It was a long time. Yeah. Anyway, circling back to the bill in front of us now. H 642, activating to youthful offender proceedings. Just to refresh the committee's recollection for a moment, when you're talking about youthful offender proceedings, you're talking about how to treat a minor in Vermont who commits criminal conduct. And I'm sure the committee remembers very well that there are options for how a minor could be treated when criminal conduct is committed. Can be treated as a juvenile in the family division, could be treated as an adult in the criminal division. Depends on how old the person is and what offense was committed. Generally speaking, the important differences between being treated in the family division and the criminal division are, in the family division, the case is confidential. It's not public. Proceedings aren't public. The documents are confidential. You get services from DCF, from the Department for Children and Families. And you don't have the consequences of being convicted of a crime. If you complete your juvenile disposition and probation successfully, then you won't have a criminal. So the big differences between going to the family division and the criminal division. Youthful offender is, when it first got started years ago, was referred to as a blended sentence because it has sort of pieces of both. It's kind of, you could think of it as a middle ground, but the way sort of generally speaking, the youthful offender approach works is the person is given an opportunity to be treated as a juvenile in the family division. So they would have those advantages that I just mentioned with respect to being treated in the family division, the confidentiality, the not having a criminal record if you successfully complete, that sort of thing. But if you don't successfully complete, you can have your youthful offender status terminated, be sent back to the criminal division for sentencing. So you can think of it as kind of a carrot and stick, right? If you're in that person's position and you want to try and not have a criminal record and get different sorts of treatment, have the whole thing be confidential, obviously the incentive is there to comply with your case plan, with your disposition, your conditions of probation, because if you don't, you could end up back in the criminal division with a criminal record and all the things that go along with being convicted of a crime as an adult. So that's the big picture. How do you end up in one place or the other? Like I said, it generally depends on how old you are and what offense you committed. I'm sure everybody remembers the phrase, it used to be Big 12. Now we kind of refer to it as the Big 14, just so you want to have a nice piece of paper to throw in your bill file. This is the list of these offenses, which you have Big 11 on one side, Big 3 on the other, because you may recall a couple of years ago, we made a bit of a distinction. So basically the 11 on the front side, if you're the young person and you commit this offense and you're age 14 or over, then you go to the criminal division, right? That's side number 1. Side number 2 on the back, there's 3 more, so 14 total. You commit one of those 3 and you're 16 and above, then you start in the criminal division. So these are the offenses that decide, depending on how old you are, whether you start in the family division or the criminal division. All right, as I mentioned, this bill, H642, deals with this middle ground, this youthful offender proceeding. So how do you end up as a youthful offender? Well, one way is all these offenses that are on this list that I just handed out, both sides. There's 2 ways you can get to be treated as a youthful offender. One of them is called a direct file. And under this direct file approach, one of these offenses that ordinarily that starts in the criminal division, the state's attorney can choose at the outset not to file that case in the criminal division. They can direct file it in the family division as a youthful offender proceeding. Hence the term direct file. So think about how that goes that way too, because if they started in the criminal division, the case starts as a public case, right? In that situation, the fact of the filing, the associated records at that very beginning point are publicly available. Once it gets transferred to the family division for youthful offender treatment, it becomes confidential, but it has that moment at the beginning where it's public. So it kind of highlights the fact that initial charging decision can be a very important one for the state's attorney, because if they choose to file in the criminal division, public, but if they choose to direct file, then it's confidential from the beginning.
So I know that Tom, I think, has a question, but before, just about that, if they directly file one of these into the family division, is there still a hearing on whether youthful offender status should be maintained?
Yes. Well, we'll get that definitely. Yeah. Either way, however you end up, though, you do have that
You
hearing.
still have that.
Yes.
Tom.
Yeah, just quick. If it starts in criminal division and it gets sent to family division,
Right.
when it started in criminal division, was there anything more than just deciding where it goes, or are they actually facing any sort of consequence in that court when they leave? Are they sentenced? So
Well,
then if they fail and family, if they have to come back?
oh yeah, I think usually the transfer, if the case is transferred, then they would come back for purposes of sentencing. That can happen again. It used to be under a previous iteration of the youthful offender statute that you had to plead guilty in the criminal division. You don't have to do that anymore. But it would come back and they could have a sentencing debate at that time. Yep. So that's one way that I handed out that you could direct. There's 2 ways to end up in the family division for youthful offender treatment. One is the direct file, that piece of paper I just handed out. The second way is by motion. So if you're in the criminal division, either the young person's attorney or the state's attorney or the court on its own motion, they can say, well, this looks more like it should be a youthful offender case. So they can motion to transfer it for the family division in that situation as well. So there's kind of these 2 ways it can get to the family division for youthful offender treatment. Either way, whichever way it ends up there, you have to have this hearing, as the chair mentioned. Either way, so the first thing you're going to do when you get there is you have what's called the youthful offender consideration hearing, right? Step number 1. So, and that is in the family division, that's confidential. So that segues us into section 1 of the bill. So you're having this youthful offender hearing in the family division, right? And the first question always at this hearing is whether it's sort of a two-step analysis. Step one is public safety going to be protected by treating the young person as a youthful offender? And the court has to answer that question. If they answer that question, no, public safety wouldn't be protected. Right. Then they send it back to the criminal division for treatment as an adult. But if they answer that question, yes, public safety would be protected, then it stays in the family division for step two, which is to determine whether or not the youth is amenable to treatment and whether or not there are services available. So that first question is public safety going to be protected? The statute has a list of, I think, 10 criteria that the court has to consider. Starts on page 2, line 13, goes all the way over onto page 3, halfway down the page. So it's when determining whether public safety will be protected by treating the youth as youthful offender, the court shall consider on the basis of the evidence submitted. And then there's this list of criteria. Won't read all the ones that are in existing law, but you see nature and circumstances of the charge, whether violence was involved, mental health treatment history, substance abuse history, et cetera, all kinds of relevant factors. So first thing that the bill does is it proposes to add one factor to that list. And that's over on page 3, line 10, whether the youth has acknowledged that harm was caused by the youth's alleged conduct. So it's sort of an acceptance of responsibility concept. And that's section 1. It occurred to me that it seems like every time I come in here, I say the bill does 3 things. This literally, I didn't plan out the way, it does 3 things. So this is thing number 1. It adds one criteria to the list of criteria that the court has to consider when they're deciding whether public safety will be protected and the minor will be treated as youthful offender. And that one thing is whether the youth has acknowledged that harm was caused by their conduct.
A through K. That's all the criteria you have to meet to be sent to family court? No.
Yes, in a sense. I don't know. The way it's phrased as the court shall consider. So these are the things the court has to consider.
Right.
It's
You don't
not,
have to. I mean, even if you meet them, do all these A through K doesn't mean that it's automatic.
right. That's the way I would read that. Right. Has to consider them.
K is just another one.
Karen, Ian, and Ken.
Thank you for this. I always appreciate the overview to get grounded in
Okay.
where we're at. So thank you for that.
Yep.
And with that, I get that we're adding one more criteria that they have to consider in order to determine if public safety is going to work out or not to
Right.
stay in court.
Yep.
But I guess with this specific one, this seems like brand new language. Do we have we used this ever before, or it seems like it's going to be controversial? Is it new or like is it in from any other laws or anything? Or like, how would you determine if a youth has acknowledged? Is there any of that?
Yeah, I think that concept isn't brand new.
Okay.
It's new to this particular list of criteria.
Okay,
But
but
acceptance of responsibility, I think, is a familiar concept.
Okay.
Generally.
in determining if it would go to a certain court or not.
Making determinations like that. What sentence might be appropriate? For example, acceptance of responsibility is a common consideration by the court.
Okay, and it's just an acknowledgement of saying, like, yes, that would fulfill this.
I don't know exactly how it would play out in practice, but I think it probably is going to depend on the particular case and the facts and circumstances of what would constitute an acknowledgement. But
Okay,
yes, seems like an acknowledgement to me.
Yeah.
Yes.
okay, great. Well, thank you. It's very interesting.
So everybody else has a question, but I'm going to jump in on this. So my understanding was that that kind of question is asked of somebody going into a restorative justice process as well. Is that not correct, or is it not quite the same question?
No, it is. And so this maybe is getting it, I'm just curious, but it's basically taking responsibility for your actions of saying there is harm. And this is before somebody has been found innocent or guilty. Where in restorative justice, it is a detour from that.
Right. Nice point. Yeah. So, and just a little further background, and I'm going to go to Ian, Ken, Tom, is that this was to try to find compromise for what's in the H 721, which is what they used to have was a provisional guilty plea. Is that what it was called?
Yeah, I think conditional or provisional.
Provisional guilty.
Yeah,
So this is short of that. But it is to try to get at the issue.
Of taking responsibility.
Right. So that, and now whether it works or not, we're gonna hear from witnesses. But Ian can comment.
Yeah, Karen mostly got my question and point, but I think just to clarify, they've not been, at this point, no one's been convicted of anything. There's an allegation and a charge, correct?
correct.
And that's it. That's my question.
Yeah. The only thing I would add, just for clarification, is that it's not phrased to require that the youth committed a crime. The phrasing is they acknowledge that harm was caused by the alleged conduct. That may or may not require that the young person committed illegal conduct.
I think it would be very interesting to discuss.
Yep, I'm kind of taking you. So.
So I wasn't gonna go there, but I'm gonna say whether the youth understands that harm was caused. I'm not really sure where we're going with this language, but wouldn't a judge, no matter what, be looking at the youth and going and seeing if how the reactions are in court and how, if there's any, he understands what they've actually done. I mean, isn't that common sense?
I think that the way this is phrased, that's absolutely, the court would be looking at that sort of thing, right? And the youth would have, if they're so desired, have an opportunity to make a statement if they wanted to go to that point that you're talking about.
So I'm gonna ask this question, but I mean, isn't it common sense that's gonna happen anyway with a judge? Policy decision or something.
Yeah, it's a sort of.
I mean, I don't get this verbiage. I don't, it's basic 101. I'm not a lawyer. I'm not a judge. I'm not anything.
Well, the youth isn't required to testify. You always have a privilege not to testify. So the way I think this is set up is that it provides an opportunity. The youth wants to take it to acknowledge the harm and thereby, by implication at least, demonstrate some knowledge about what may have happened as a consequence of their act.
Right. So you just said the youth has the ability not to testify if he doesn't want to, but the youth can testify anytime they want, or
They could choose to.
I mean, that's already there. It's accurate.
Well, yeah, I think it's generally true for a defendant. Yeah, they could choose to waive their right against self-incrimination and testify.
I'm not sure who to ask, but what precipitated putting this back in here or bringing this into?
Okay,
Yeah,
I think that's what I mentioned before, that another proposal was to bring back the conditional guilty plea. This was something that was trying to get at that without having to have a guilty plea because it's before they've been adjudicated. If it doesn't work, it doesn't work. We'll just.
I hear you. I mean, it looks very much like a drug court scenario to me.
You got a plea agreement for that.
Well, there's conditional plea of guilty. I would imagine a plea agreement would go with that.
This is very.
I had the same kind of question that Karen did, but I kept reading it and kept reading it. It made sense after I read it like 3 or 4 times that there's not some kind of admission.
It's not admission to
Right.
unlawful conduct.
Right.
No, not.
Whereas a conditional guilty plea is.
Yeah, my original thing that I raised my hand for was that the way that I look at something like this is that the youth isn't going to acknowledge anything. They're just going to the lawyer's just gonna write something up and if they're listening, you know, to what the lawyer is telling them, they're just gonna say, yeah, what he said. So,
All right. So. All right.
All right. That was number one, what the bill does. All right. Number,
I saw 4 points in the bill, but go.
oh, maybe you're right. Maybe I forgot one.
Let's talk about which, how many comes.
The second one, though, we'll total them up at the end, I guess, but the second one, so think about sort of where we are on the chronology here. So we were just talking about, let's say the court does find that public safety would be protected by treating the young person as a youthful offender. And let's say they then have to add at the bottom of page 3, the court then will grant them line 18. Court grants the motion, the next two things that the court turns to. It finds that page 3, very bottom line 18. So you're at the point where the court has found that public safety would be protected. Then they have to consider whether the youth's amenable to treatment and whether there's services available. So the court will grant the motion. In other words, treat the kid as a youthful offender if the court finds that the youth is amenable to treatment or rehabilitation as a youthful offender. Turn on to the next page. And there are sufficient services in the juvenile court system and DCF and Department of Corrections to meet the youth's treatment and rehabilitation needs. So that's the next step. All right. So let's say that happens. Then you go to subsection C. If the court approves the motion for youthful offender treatment, then the court, lines 6 and 7, shall approve a disposition case plan and impose conditions of juvenile probation. So that's what happens, like a juvenile case at that point. It's a disposition plan, disposition case plan, conditions of juvenile probation. All right, what happens if the youth violates these conditions of probation? That's point 2 of the bill. So turn over to page 5, see line 7, section 2, modification or revocation of disposition. So what happens if the young person violates what their juvenile probation terms are? Well, if you look at line 8, the state may file a motion for modification or revocation of their youthful offender status. So that's kind of like, remember I was saying it's sort of like a carrot and stick. Well, here's the stick. If you violate your conditions of probation, the state can come in and file a motion, look at line 10, for modification or revocation of the youthful offender status. Court has to hold a hearing on the motion and then go down to the very bottom of page 5. What if the court finds the youth has violated? There's several options available. Look at line 20 of page 5. Important point, important word. If the court finds that the youth has violated, the court may. See that? That's discretionary. Court may do those things. Court may do the things I'm about to say. Go turn over onto page 6. What may the court do? Subdivision A, line 1. The court may maintain the youth status as youthful offender, but modify their conditions of probation. They think it's appropriate. Second thing the court may do, court may revoke the young person's youthful offender status, transfer the case back to the criminal division for sentencing, right? There's that stick. Violate probation, you can go back to the criminal division for sentencing. All may, though, all discretionary on the part of the court.
Yeah, thanks. Before I get lost too much further down the road here.
Yep.
So going back to line 7, the modification of,
Yep.
why aren't we already doing that?
Say it again, sorry.
Why aren't we already doing that? Why isn't that already?
Oh, this is existing law. Sorry. This is the way it's
Oh,
done.
I got it. Modification.
Or revocation.
Okay, so what are we changing?
Oh, we're about to get to that. So this is what the court may do, right? If the young person violates now. What the bill proposes over on page 6 is to say in a couple of circumstances, the court shall revoke the young person's probation and send it to the criminal division, right? It may remind you instead of may, exactly, shall, in a couple of situations. And those two situations are, look at lines 10 to 12, line 6. If the court finds that while on juvenile probation, the youth was charged with a crime, element of which involves an act of violence against another person, see line 12 again, the court shall, see, not may, court shall revoke the youth's status as a youthful offender, transfer the case, and that's just the same language that it's a repeat of the exact language that's on lines 3 to 5 of the same page. So it's the same procedure, it's just that it's a shall in that particular situation. If the youth is charged with a crime, an element of which involves an act of violence against another person. Now, just to fully explain that, it is shall, but there is look at line 15. the youth does have an opportunity to show that they should still be treated as youthful offender despite that. So unless the youth proves, so the burden is on the youth, right? Burden is on the youth to show by a preponderance of the evidence that, and that's A and B at the very bottom of page 6, public will be protected by continuing to treat the youth as a youthful offender, and the youth remains amenable to treatment or rehabilitation as a youthful offender. And that's the same language that's in the treatment, the decision the court has to make in the first place. So it's kind of like the youth having to show, well, look, I should still be treated as a youthful offender. I still am appropriate for youthful offender treatment, despite the fact that I was charged with this other crime, an element of which involved an act of violence against somebody else.
Karen, then Ken.
Maybe you clarified it. So it's not convicted, it's charged. So
Correct.
you haven't been actually found guilty of the behavior, but you could have some kind of punishment.
Right. And that part is still the case. I mean, that could be a violation of probation.
Yeah.
You could be charged with a crime anyway.
Yeah.
Yeah.
Yes.
Okay, Eric, I apologize. So everybody, I apologize. I'm trying to catch up to this. So on page 6 on line 12, you got, that's the first place where I see shall, correct?
I think so.
And then if I back up where the may came in was on page 5. Line 10.
Line 20 is one place. Yeah, there is one on line 5 also. The crucial one, though, is line 20. See the may, the last word of that line.
Okay, okay. So that's, okay, so run that by me one more time. Line 20 is where the court.
So right now, if the youth.
Okay, I got it.
So that's the first instance in which revocation is required. So there's two. That revocation would be required, assuming the youth doesn't show that they're still appropriate for Wiley treatment. But the second situation in which revocation would be required absent another finding is over on page 7. We look at subsection.
Before we,
Sorry. Yep.
before we go on to 7. Bottom of page 5. Court finds after the hearing, the youth has violated the terms. The court may, right, and then A, B, and C.
Right.
So I violate A. And the court may or may not put me into, the criminal division.
Right.
So it decided that I stay in family court, violate A again. There's still that choice to go either way. Violate A again, there's still the choice to go either way. There's nothing that says if I keep violating that there's a shall in there.
I don't think so. I think it's discretion of the court.
Right.
Right.
That's what I thought.
Right.
And, it's the same down below, and I forgot where it was now. But anyway, yeah, that seems kind of odd to me, that especially when you're talking, the big 14. They obviously haven't got the message, or potentially somebody hasn't got the message if they keep violating their conditions. Not really a question. I did have a question you answered, but.
Right. Ian and then Karen.
Oh, I'll defer. Okay.
And then Ian.
Yeah.
Senior member.
So it says youth was charged with a crime, an element of which involves an act of violence.
Right.
So is that up for interpretation, or is it clear, like there's a list of these crimes, or it could be, Judge, I think this has an element. You could argue it.
You could argue, and it is argued, because that's actually the same language that's in the bail statute. That's where it's
Okay.
Copied from, because the courts have had experience with litigation between prosecutors and defense attorneys about whether an offense contains such an element, and been going on for quite a while. So the idea was to use a standard that the court was familiar with.
Okay.
That's where that's from.
Just one quick question, Eric. The for number two, the crime of violence that the youth has been charged with, that charge does not need to be what has provoked the violation of the youth probation. Correct?
You mean that, because the condition that the youth violated could be something other than the intervening crime?
Correct. Yeah. Or at least I'm wondering if that's how that reads, because I'm just curious if you've got somebody who's on probation, who's a youthful offender who's on probation. They do get charged with a crime of violence early on, but they choose not to. They are successful in providing providence of evidence not to lose the youthful offender.
Yeah.
But then they have other violations. Would this still be invoked again for each of those violations after the fact because they were charged with a crime of violence during their probation?
Like, in other words, there could be separate violation proceedings, always related to the fact of the one additional crime that the charge.
That it would just like automatically shift into this number two because while they were on probation, they were charged with a crime with an element which was violent.
Yeah, it could potentially work out that way.
Okay.
I think you're right. It doesn't need to be the violation,
Yeah.
right? And so could be the trigger each time,
Each time.
right? Right.
Okay.
I
I don't know if that's like if we want it to be that it's the actual charge of the violent crime that gets you into number two, or if it's just the fact that you have been charged with one while you're on probation.
I'm not sure where to at with this myself, but
Okay.
so I'm confused.
Okay, maybe I wasn't. Yes.
So they're on probation, they're charged with a violent crime, isn't that? I'm not following.
Yeah. So you're on probation, you're charged with a violent crime. That will put you into number two.
Right.
But then let's say they satisfy, they don't get kicked out of probation, youthful offender probation. They're able to, they make the showings and they're successful. They're on probation for 5 years. 3 years down the line, they have another violation for something else. They violate some other term. Would it just kick them back into number two because while they were on probation, they were charged with a crime of?
No, but it's been dealt with once, presumably. I mean, I see what you're saying. But I don't see how that.
Okay. I guess how I read that.
We misused that term before, but I mean, it's like you've already shown that. Yeah, let me think about that, Tom. I understand what you're saying, but yeah, Tom.
Yeah, so Aaron, the same section on page 6, that the court finds a hearing that while on juvenile probation. Now, is this implying that they're on juvenile probation because of one of these 14 offenses or any juvenile probation?
It's whatever offense got them to youthful offender status. Could be one of those 14, but for example,
that's stealing a candy bar, or it could have been manslaughter.
well, the first one you mentioned, it's always going to be in the family division as a misdemeanor.
Unless they're 19.
Unless they're 19, that's true. In theory, it could be, right? So it's whatever offense got them to
Which
the
is
family division for youthful offender treatment in the first place.
Does that offense have to have the first offense that got him on probation?
Right?
For this to apply, does that have to have the potential to go to criminal court? Or it could be simply a matter that.
The first offense, the one that got him to youthful offender
Right, that's.
in the first place?
Yes.
Yes, one way or another. Either it's a case the prosecutor could have filed in the criminal division to begin with, which is one of those ones on the piece of paper. Or it's one that was transferred to invoke the ping pong effect, no. But yes, it was one that would have been transferred to the criminal division and back to the family division for youthful offender treatment. One way or another, it would have been in the criminal division. Unless it was direct filing.
So I'm just trying to understand this.
Yeah.
So the first offense, I got him on juvenile probation.
Yep.
Chances are it's a pretty serious crime. Not necessarily one of these.
I'm going to defer to the practitioners on the percentages of how many of these YO cases are serious. I think many of them are.
Right. And the reason I'm thinking potentially a serious crime because it could be in criminal court. More serious crime.
Some of that, right? If it could be that the court or the parties had agreed in the first place that it should stay in the criminal.
Right. If that is the case, where it is potentially a serious crime, I would have some issues with number 2 because they've already done something fairly serious and broken whatever conditions have been handed down and they're doing an act of violence after a serious crime. I mean, that's grounds for some serious accountability. So.
Ken, did you have a?
I'm still trying to catch up with this whole bill. It seems like we started out with a little fishbowl with this, and now I'm down in Florida at SeaWorld in a fish tank. It's like
Now you have to explain that before the bill gets explained.
well, it's like it's
6.5.
It's like going all over the place to try to like do something that already should be enacted. And I'm trying to understand what I'm missing here. And I really don't have a question. I just. I'm in the fish tank, man. I'm just.
So, I mean,
Get us out of the fish tank.
well, yeah, so there's this language here that was trying to do something, I can't remember what, because it was last fall.
Is it your bill?
Yeah, it's my bill.
And you don't remember?
Well, it was a while ago. I had a discussion with, we had a few people. I'll blame Tucker and Kim and everyone else was at that table back in September. We just
Take
give,
responsibility.
well, it's my fault. My name is on this bill. I'll take full responsibility for this. So we don't, have to have that language, presumably with the May language, if it's a serious crime that they're in there for and a serious crime that they have now committed, there's a pretty darn good chance that the court is going to sue. There's a decent chance that the court's going to transfer the person over to criminal court. It's going to revoke it. So this may be surplusage here. It may not be necessary, but we were trying to force that, say, hey, if this happens, you have to send them there. But then again, we have the escape clause. So are you sure? Let's move on. Yes, Ken, go ahead.
Don't we? Is it just in the I can't pronounce the word, omnibus bill already from the,
Yes, and you have the pages that it's in there. That's
so,
They're different.
okay,
Yeah.
so you know where I was going with that.
you good?
Not really, I think we gotta go to the other one, maybe I'll
I think that we would be having even deeper issues, but that's just me.
oh, I'm deep.
Eric, over to you on page 7, I believe.
Oh.
I would count this as the third point, but I think you're counting it as 2B.
No, I think you're right. I'd agree. I'd concur with your interpretation. 4 points. So
So if guys didn't like the last one, that's it. You really got
I already looked ahead.
All right, go ahead, Eric, sorry.
So this is another situation in which rather than revocation of probation being discretionary for the court, the idea is to make it mandatory. So make it mandatory in this fact situation if if the youth fails to appear at a probation revocation meeting. So in other words, we saw when we were going through this that if the state files a motion to revoke the young person's probation, the court has to have a hearing. Well, if the youth fails to appear at that hearing, then this provides that their probation gets revoked. Again, there's an opportunity to see line 2, unless it finds there was good cause for the failure to appear. So if there is good cause that the youth can show, then the court doesn't have to revoke. But if there's no good cause, then the youth has to revoke. The court has to revoke probation, send it to the criminal division for sentencing, rather than it being discretionary or permissible. The court is required to do. So it has these two situations: the committing another crime while you're on probation, an element of which involves an act of violence against another person, or failing to appear at a probation revocation. In either one of those two situations, court has to revoke probation, absent some other circumstances, rather than discretionary ability to revoke probation. So that's numbers 2 and 3.
The shall and unless kind of way of doing it, but.
Right.
Okay.
And the last piece of it involves victims' rights at youthful offender proceedings.
You're gonna like this.
On page 4.
I think everybody's gonna be on board for this one.
Well, the victims,
Interesting law.
crime victims already have a number of rights at youthful offender proceedings. You see they're listed in the statutory section that's on line 16, page 7. The first, as turn over onto page 8, the first right that is listed that they have generally is notification. So in the youthful offender proceeding, the crime victim has the right to be notified by the prosecutor about court proceedings, conditions of release, that sort of thing. The second type of right they have under subdivision 2 starts on line 7 is to be present and to make a statement at certain parts of the proceeding. Existing language, though, you'll see if you ignore the underlined language for a second on lines 8 and 9. The part of the proceeding that the victim can be present at and make a statement at is the disposition hearing. That's on line 9. And they can prevent a statement at that hearing. Now, remember when we went through this sort of type of proceeding, there's two hearings, right? The first hearing was the consideration hearing. That's where the court decides whether the young person is appropriate for treatment as a youthful offender. If the court says yes, then they have the disposition hearing, which is developing the disposition case plan, the conditions of probation, sort of like imposing the sentence, sort of thing. So with this, and under existing law, the victim can appear and make a statement at the disposition proceeding. But at that point, the decision has already been made to treat the person as a youthful offender, because that was done earlier at the youthful offender consideration. So what this does is it allows the victim the same right to appear and make a statement at the youthful offender consideration hearing as they currently have at the disposition hearing. That's it in a nutshell. Basically an earlier stage in the proceedings that the victim can make a statement, and it's at the time when the court is still deciding whether or not to treat the young person as a youthful offender.
Yeah.
Let's go through.
More question. So on the, for that section 2, but if you look at lines 14 and 15, it says the court shall consider the victim's statement when ordering disposition, but it's not saying that it should consider the victim's statement when deciding youthful offender status. Is that intentional or?
It is not intentional. So I'm going to say good catch.
Is that also a disposition?
Although, yeah, to be consistent,
It's a difference up above. You
yeah, I'm looking at
clearly
page.
point out too.
Yes, so I think you're right. It should be made consistent if that's the policy decision.
Yeah.
It's also kind of an outlier in the sense that, because over on page 9, when there's some more detail in subsection B about the procedure, it does say there that in ordering youthful offender, I'm on line 6, youthful offender, in ordering you, it does add youthful offender status there. The court shall consider any views offered at the hearing by the victim. But you're right, for purposes of being consistent, we want to add it there too.
Any other questions for Eric? All right. I would say I had one other question is that if something manages to get through, we probably have to have a different effective date than on passage because it's a definitely need to roll out presumably.
Right.
All right, so we will go to our next witness, and I believe it's Kim, Kim or Tucker. Who wants to go first? We'll let you flip a coin. Sure. All right. You're playing.
Is Tucker using that double-sided coin again?
Probably. Well, before you identify yourself, Bryce, so I'm hearing there's some pushback on some of these, some of these things I have in there as far as language. So definitely want you to discuss those. And if you have any like conceptually or from the other Bill 721 to just kind of put before us to think about and perhaps in the next version, we're open to hear that, but that's also fine if you don't have that right now. If you just want to attack the painstakingly put together.
I'm here to help.
Thank you. As you can tell, I need it. So if you identify.
Kim McManus, Department of State's Attorneys and Sheriffs. So stepping back a second from the language right in front of you, what we appreciate about this, what this bill is trying to do is that it feels like the committee heard us last year that there are issues within youthful offender. There are a number of issues, but one of the issues is that when someone is on youthful offender, there is an ability for youth to age out and sort of run the clock. And if they don't appear at hearings if there's a motion to revoke and a hearing schedule, if they do not appear, there's currently not a mechanism to move that case back to criminal court without them being at that revocation hearing. And the clock is able to run, and then the family division no longer has jurisdiction over them, and we've lost our window of having accountability on that case. So my understanding is that this bill is seeking to address some of that, in addition to making it clear that the victim can speak at the consideration hearing and be heard on whether or not youthful offender is an appropriate way for the case to go. I can definitely hear from the room. There are different opinions essentially on how soon and what sends these cases back to criminal court. And from our department's point of view, yes, there could be more to this in terms of what sends things back. But there is an initial start here of what would be a firm line in the sand for youthful offenders to know if you do not comply with probation, you will go back. Now, to Representative Burnett's point of view, up to your committee whether it's a matter of so many probation violations and then it has to go back, or is it an allegation of a certain crime while on probation? Does that send you back? Like that's what I believe this bill is trying to do and to start that conversation. I'm going to start with the easy part as far as my particular comments.
The very end.
What's that?
Very end.
The very end.
Yeah.
Not the effective date. That's the really. Agree with the chair on that. No, so for victims involvement, what we had represented to the committee last year I don't know I think it came up last year that courts are reading this section of the statute differently. Again, as Representative Burdett said, like, hey, I think this is already law that the victim should be able to be heard at the consideration hearing. Some judges do interpret the statute that way, and some do not. So this was something that we requested to clarify. I think the the wording is a little complicated right now, and we could probably make it simpler. In that, I think the wording on page 9 clarifies when considering the youthful offender status, meaning that consideration hearing, that's when they can be heard and that the court shall take that into consideration. The wording on page 8, I think, is confusing. And so I would suggest maybe taking that out and just sticking with page 9. And if you did that, potentially moving that added language on page 8, line 11, the appropriateness of youthful offender status, that's what that's what the victim is able to speak to at the consideration hearing. You could move that into page 9, probably right around line 7 or so. So that's one suggestion, just that might be a little easier. This way, subsection 2 on page 8 is talking about what the victim's rights are at disposition hearing. Page 9 is talking about victim's rights at the consideration hearing. It might make it a little easier to understand. Just a suggestion. Diving into the page 5, the modification or revocation of disposition. The way the bill is written, my understanding is, well, sorry, let me back up a second. Current law allows anyone to motion to modify or revoke a youthful offender's status. So there are times when the defense might want to modify the conditions that the youthful offender is on, doing a file motion to do that. The state might want a motion to revoke youthful offender status. The way this is written, there are now 2 ways that we could support that motion. One, a probation violation, and then the new addition is this language around whether someone's charged with a crime which involves an act of violence against a person. So that's just another, that would be providing another avenue for the state to file that motion to revoke. Whether or not you all think that's appropriate, that's up to you all to decide whether a charge is enough. I believe what Ledge Counsel was stating was if a juvenile on probation is charged with a new criminal offense or a juvenile delinquency, more than likely that's also going to be a violation of their probation. So we still could do that under what we already have. The question before this committee is what behavior, while youth is on probation, gets them out of this youthful offender status, right? Which is a benefit to them to not be in criminal court. So what sends them back is ultimately the question for you all. And we as a department do not have 100% agreement on what that would be. I can say that the majority of our state's attorneys want a line in the sand for when, okay, we're done. We've tried this, it's not working anymore. You are showing us that you are not engaging in treatment. You're showing us that you're not benefiting from the status, and it should go back. I know in, okay, so that's, so we support anything that firms that up. Where you decide to start drawing those lines, I'm not going to get into too deeply because it sounds like there needs to be a lot of conversation amongst you all before bringing us in.
Thank you, Chair. Kim, so the line in the sand, are you guys going to take a stance on where you think that should fall? Or are there any suggestions that the essays do currently have?
Again, we don't have 100% agreement on where that would be.
Does it, and I don't mean to interject, I'm wondering if this might be helpful. Does it kind of go back to page 1 of 642? And, it seems like I'm looking at lines 12, 13, 14, it kind of, there's several varying degrees of where if the youth isn't an active participant, if the public safety is not going to be upheld by the youth, there's several conditions I feel like that could be met. Is that kind of in line with, you only get so many bites of the apple and there's the line, or is it something? Is it the type of offense that the youth commits while they're out that will be a line? Do you understand what I'm saying? Is it the preconditions that are kind of outlined here, or would it be more practical to have a certain penalty or offense that they commit?
I think what gets tricky is that there'd be many possibilities of what would say the state's attorney, like, this isn't working.
Right.
So yes, potentially being charged with multiple crimes while on probation. Like probation does not seem to be impacting your behavior. Being charged with a violent crime for some state's attorneys would feel like that should be enough. But on the other end, it could be that continuous lack of engagement, like just low level, like just running around DCF and not engaging, right? Like, so I'd be hesitant to say like this.
One thing.
Yeah, but so we'd want, but I think the important part is that the factors that allow them youth into youthful offender status, right, should be similar factors that you're weighing at that revocation hearing. Like you're sort of running through the fact, or ideally the judge is running through those factors again, right? Given whatever new information has come to the court. And many judges do that, even though that's not required. They often will run through that analysis as why they're keeping someone in youthful offender or why they've decided to revoke.
Yeah, no, thank you. And I think if I could just, just line 12, I think it's interesting because it says, unless the youth shows that the public safety will continue to be protected, it really shifts the burden on the youthful offender. And I'm curious what your thoughts are on that. I am very much in support of that language. I think it's a great modification here.
And I appreciate that you pointed that out. Yes, we do support that. That, you've been given this benefit of youthful offender, and then you're exhibiting behavior, whether that's violating probation or allegedly committing new crimes, that it would seem clear to us that the burden shifts, that you're essentially arguing for why you should be able to maintain that benefit.
Right.
So we do support that.
Thank you.
Yes.
Before I go to Ian, is that one of the possible solutions here is if we can't figure out exactly what this line in the sand is, that lay out what we want the court to consider specifically or explicitly?
I think it could be, because I do think that, again, you see a wide range of responses to these motions to revoke when presented. And if judges needed to make a more detailed finding on the record as to why they're deciding someone should stay in youthful offender, even with a probation violation or with 2 or 3 probation violations, or why it's being revoked, do you think that would be helpful? And with, again, the burden shifting.
Yeah.
Quick question. Can you revoke a adult probation without the probationer being there?
I do not believe so, but I would need to. But again, it's easier in criminal court. At least someone doesn't show up for their probation.
Yeah.
Revocation that an arrest warrant is issued.
Yeah, and yes, that makes sense. And I think the issue around running the clock out and, not showing for the revocation hearing for the youthful offender side of it, that makes a lot of sense to try to resolve that issue. I was wondering if any of the reasons, if you can't revoke someone's probation as an adult, if any of the reasons why you can't, if they're not there, any of the reasons why you can't do that as an adult, if those also apply for a youthful offender, beyond the fact that you can do an arrest warrant, but if there's any other reasons why we're not allowed to do that, I'm wondering if they would apply here as well, for why maybe we can't revoke someone's probation as a youthful offender because they're not present.
I mean, the big picture is it's a due process issue, right? Do they have their
Yeah.
hearing? And so the question is, again, if we're treating these youth, who some of them are adults, differently, right?
Yeah.
We're giving them the benefit of youthful offender. Can you treat that differently? And again, I'm not prepared to speak of to that in detail. But I do think as long as if the case is transferred back to criminal court, the individual is going to have, an ability, a moment if they show up to court
Yeah.
to make an argument, potentially to send it back.
Yeah.
But if they're not, we need some mechanism to get them either into family court or into criminal court if they're not showing up.
And I think that kind of gets at it that the consequence for revoking youthful offender probation versus the consequence of revoking just an adult probation are very different. And so the due process consideration can be different as well.
Well, to be fair, I mean, revoking a youthful offender's probation, you go back to criminal court, they're sentenced on the charge. So that's
the next step.
significant.
Yeah.
So again, they would need that a hearing to sort of affirm, right, that why the case has gone to criminal court.
Yeah.
But I'll leave the defender general to control that.
Yeah. Okay. Thank you.
Coach, do you have a question? If so, unmute.
Yes, just, Kim, thinking about, the process and thinking about family court and the fact that the youth will probably have, possibly a, guardian ad litem, and additionally, be part of a local interagency team function, which the state's attorney's office is part of that local interagency team. When we look at, for example, possible violations, do you think things, like such as, not going to school, or completing certain agreements that are made between the team and the court, around attendance, would come into play?
So if attending school is one of the probation conditions for the youth, that could be a violation of their probation. Now, whether a state's attorney is going to motion to revoke for that reason, that would depend on the state's attorney. But that's why the court has the discretion. Say a probation violation was filed because you are missing school and you are supposed to attend school, they could find that as a violation, but then the court has the discretion to either keep the youth on youthful offender status or revoke. So it is possibly a probation violation. Whether that would cause you to be revoked, say the odds are unlikely, but it would very much depend on the whole plethora of what the youth may or may not be doing.
Right. Like you said, I think the key issue is what are they doing with that time? If that time is, let's say, unaccountable for, when the whole idea is where they are if they're there, versus if they're out running the roads, that's a whole nother issue.
I think that's fair.
Anyways, thank you.
Zach.
I'm just curious. I'm kind of going through this with you as well. But if you go to page 4, line 10, and then I'm also looking at the top of page 5, line 1, and then I'm looking at line 15 on page 5 as well. It seems that there's contradictory language in terms of the youth's age and the relevance to the situation. So I'm curious if the department has a view on whether there should be consistency across, whether there shall be 22 years, if it shall be 18. It just seems strange that we're waffling back and forth.
So what gets tricky, what gets tricky with this, and we'd really have to chart it out.
Right.
And that's what I have to do every time, is that the court has jurisdiction up to 22. On page 4, it's discussing that the court may transfer legal custody of the youth. Like, that's different than court jurisdiction. So the court could transfer legal custody up until the youth's 18th birthday. But our big issue, right, with youthful offender is that once they turn 18, doesn't matter what their parents are saying or not saying to them, matters only a little bit what DCF is saying to them. They're making their choices and the court still has jurisdiction over them, but they are, for all other purposes, an adult making their decisions.
Well, I think this goes back to some of maybe the push and pull that we had last year around this time on the debate of raise the age, is that there's one way that society views these individuals and there's another way that the court views these individuals. I think that's kind of the tension that I'm picking up on in this piece of legislation, is that while very well intended, it seems like there are some points that maybe aren't fully considered. That my words, not yours. I mean, that's a wide open invitation if you want to discuss it, but it just seems like there should be some kind of consistency.
A youthful offender does live in this murky middle where it's, for some, not all, those who are 18 and over are adults everywhere else, but treated as a youth/juvenile in youthful offender. So that is a tension. But we as a state have decided that this is helpful for certain cases. So again, this is to you all where this goes. But as long as youthful offender continues, our department very much appreciates having some backstop to not run the clock out. And I do think this bill is seeking to address that. And we support that. I would guess that there's going to be potentially some edits done. And we'd be happy to speak further on where you feel that place is to send the cases back. The only other comment I want to make, and this was everyone's least favorite section of the bill, so I'll leave this for last and then I'll let Tucker take over. Get you all fired up. So on page 3, the addition of this factor, again, we appreciate that what DCF said last year was when they're trying to figure out whether they can supervise this youth on youthful offender probation, which is factor H for the court, right? Like, is this youth going to be successful if they go to youthful offender? We did hear testimony from DCF that a youth's willingness to recognize that they've harmed someone, that they were the cause of that harm, is an important piece of that. Absolutely, when I read this, I thought, oh boy, there's no way the Defender General is going to allow any youth to acknowledge harm at this stage. The only thing I would put out there for consideration, if the committee did want this to be a factor for the court to consider, and there could be scenarios where this was helpful to the court. Maybe all the other factors, the court is saying, no way, youthful offender like this is to go to criminal court. But there's a youth who is ready to say, I can't believe I did this, but I did, and someone was really hurt, right? If they said that at a determination hearing, maybe that would sway a court to send a youth to youthful offender. If this language was to say, I think you would need some additional protective language about how anything said by the youth at the determination hearing could not be used at the merits hearing if it went to youthful offender or in a future criminal court case. So I think there is a way to protect that information if you all thought the youth providing that information at the determination hearing would be helpful.
Good question.
Yeah. Tim, how familiar are you with section 7 and H721? That's the omnibus bill.
A little bit, and I did see that there were some additional factors suggested in there.
Yeah, I know you can't probably answer the question with, so comparing,
Thank you.
comparing section 7 to H642, I think section 7 has got more accountability in it, and I guess if you could rate them as far as accountability goes, and I don't know if you can answer it that way or not, that's why I said I don't know if you can answer it.
Well, what I did like, so again, and I was not able to go side by side.
What page are we
On
on?
these two, we're on page
That's kind of
14, section 7. So the beginning of section 7 for the determination, again, that moment of the offender or keep this in criminal court. I did appreciate the addition of factor I on page 16, which is has this individual been a youthful offender previously, and were they successful or not? Thought that was a good addition. The section 7 also, it highlights the public safety piece of what the court has to consider. That public safety piece is already in law. It's sort of the overarching sentence, and then we get into how the court decides the public safety piece. But this bill, H7721, definitely highlights and again requires the court to further make very specific findings on the public safety side of the consideration. Beyond that, I didn't have enough time to read, so I can only speak to those two things.
Right. Eric, how'd this go? Yeah. Any what we can do side by side on it? I'd like one.
Yeah, Eric, do that.
Yeah, and I'm happy to come back if we're looking at these two sections, one bill and the other one together, with a little more time, I could come back and offer a comparison.
Thank you.
Yeah, because I did think there were a number of beneficial items in there.
Any other questions for Kim? We have one more with us, and well, I think we might have to start today.
Wow. So we're on the floor at 4:30 or 3:30, but that's today.
I was just gonna say, you were just about freaked me out. So Tucker, join us.
I like that pile of notes, Tucker.
Buckle up. I'm kidding. I don't have many. Hello again, back on the record, Tucker Jones, Department of Public Safety. Thank you for having me in on this bill. The Department of Public Safety is involved in this topic primarily because back in the pandemic, the commissioner would meet regularly with local law enforcement during the legislative session to get a feel for what was happening on the ground at that time. And there was a significant amount of feedback from local law enforcement of interactions with young people in which there was some sense that they knew because of their age that the likelihood of them being brought into criminal court was low, and that there was a oppositional defiance towards the law enforcement officers who were apprehending them in some circumstances for quite serious offenses. That was somewhat surprising or shocking to the law enforcement leaders who were involved in those cases. It was primarily municipal law enforcement officers that were kind of reporting those back up because the nature of the offenses that Vermont State Police dealt with on the highways, it didn't encounter this as much. At the same time, or at a similar time during the pandemic back in 2021, so this brought this general topic onto the radar of the commissioner, and it was of some concern that we were having these experiences. Now, granted, it was ultimately a collection of anecdotes of experiences, but they were alarming enough and consistent enough that it resulted, I know at one point in the Bennington County State's Attorney, the Bennington Police Department, putting together kind of a presentation on some of the concerns they were having. There was some legislative discussion about it, et cetera. At the similar time, DCF had written a memo to the legislature back in 2021 outlining some proposed changes to juvenile jurisdiction generally, delinquency and youthful offender to address concerns that they were having regarding youth's engagement with the juvenile justice process from the probation officer perspective. All of it during this whole time, this was being dealt with in Senate Judiciary. They always owned this topic. And so it's only really in recent years, last year and this year, that you all are now owning this topic. You addressed raise the age last year, but now you're faced with this. Since 2020, 2021, over the last 2 years, that is when we were collecting the feedback from the DCF social workers and the deputy state's attorneys that were handling these cases. And that was some of the feedback that I gave you last year when we were talking about raise the age. It's the so-called weather reports from the practitioners who are handling these cases. And if you recall, that feedback from those two groups was quite critical and consistent between those two groups. And as a result, in part, there was a delay in raise the age, kind of a timeout there. What you're now grappling with, youthful offender generally, with this bill, some of the other bills, is that those concerns that were originally raised in 2020, 2021, there was some incremental changes that Senate Judiciary made over the years, but there are large outstanding kind of changes that were not made, that were originally proposed back at that time. Now we're 2026, those gaps are still there. Those kind of concerns or critiques are still there. Chair Lalonde, I think what you're approaching here is to say, all right, if youthful offender is going to stay and it's going to serve some important role for this under 22 crowd, to make sure that it addresses those underlying concerns that have been identified from practitioners over the years. That, I think, is the thrust of the logic here. The logic is that the status quo on some of these provisions is not adequately addressing or kind of incentivizing engagement with the youthful offender process the way that some of the practitioners would like to see, especially specifically for the youth who don't want to voluntarily engage. Of course, for some who walk in and say, yes, let's do it, I did this, and I want to engage, well, we don't have a problem there. We don't need procedural provisions to address that. It's really the behavior of those who may have engaged in some very risky behavior that really did seriously impact public safety, who are not willing to voluntarily engage with the process. The question becomes, what do you do then? So I just give that background because it's, for better or worse, Representative Lalonde has kind of assumed ownership over this baby of juvenile justice, and it's a lot, but it's an important one because the practitioners have been, expressing concern over the years. And I would suggest that some of that concern over the last 2 years that they've been expressing is due in part to the failure to kind of make some of these more significant changes that were originally proposed back in 2021. Overall, what I think the goal is to create procedural provisions here that incentivize acceptance of responsibility for young people's behavior and incentivize meaningful engagement with the process to move by it, path through it. One of the criticisms that, again, goes back 5 years now is that the current procedural process for youthful offender status doesn't do that. It doesn't meaningfully incentivize young people to accept responsibility and to meaningfully engage with their DCF social workers once they reach probation. And I think it's a legitimate criticism from the practitioners for some of those cases in which people are not engaging. The other goal here is to really incentivize a view for these young people that this is an opportunity for them, and that they have to that they view it as an opportunity, take it seriously, and realize that if they don't take it seriously, they can lose that opportunity. And I think, again, procedurally, in the provisions that we currently have, we're not necessarily conveying that message. And as a result, in some of the cases, the social workers and the prosecutors are quite frustrated because it's almost like the procedural process is working against the goal of what we're trying to, instill into these young people who have this opportunity to move past this, but are kind of turned off from the whole process as they move along each step of the way. To that end, as it relates to this, well, before I speak to the 4 terms of this bill, the logic of the conditional pleas in criminal court served that goal originally of incentivizing acceptance of responsibility and viewing this as an opportunity in which you can lose the opportunity if you don't meaningfully engage. The legislature shifted away from that as a policy decision and went to this idea that first you can have this determination hearing of whether youthful offender status is appropriate, and then have essentially a bench trial with a judge to determine whether you actually committed the offense if you want to challenge it. It's a totally different approach to it, and I think for better or worse, we've lost some of the value of the value of acceptance of responsibility and viewing this as an opportunity for some of the youth. Now, in this bill, H642, the first provision here about adding a line to the factors that the court considers for protecting public safety of whether the youth has acknowledged the harm that was caused by the youth's alleged conduct, well, that's an attempt to get at that issue, this issue of acceptance of responsibility that will result in meaningfully engaging with the services available. However, as some of you kind of pointed out, as you're grappling with this language and where it fits procedurally, it is tricky because you have this opportunity to accept responsibility, and then you also then later have the opportunity to have a bench trial to say, I didn't commit this offense, or I don't want to accept responsibility, and then put on the evidence, prove beyond a reasonable doubt to the judge, prosecutor, that I actually committed this offense. So there is that disconnect there. There is a disconnect there. To Kim's point, saying, well, first of all, that could be of benefit to some youth who do want to accept responsibility and get the benefit from the judge that this is a factor that they can consider in determining whether public safety will be protected. Because again, that would be, if that is a factor for public safety, they're informed of that, they want to accept responsibility, then they could get that benefit. I appreciate Kim's point, though, that you may want to insulate that admission at that time from any subsequent hearing on the merits, if there is a subsequent hearing on the merits. The hope there in that YO as a factor in the YO consideration is that not only would they accept responsibility there for public safety, but be willing then to admit to some version of the charge and have some stipulation for the court and not proceed on to a merits hearing. That would be, some of the logic there. But I appreciate, your concern here of where this fits in to the procedural posture. It highlights the whole point that the shift away from the conditional plea in the first place kind of creates these problems. And the way I'm phrasing it is it's shifting away from incentivizing the acceptance of responsibility that can be, from the social worker's perspective, helpful to the rehabilitation of the youth once they are on probation.
A question. So this is learning about history that I didn't know about of the conditional plea. So that was a part of the youthful offender program at one point, is that you had to plead to something. And if you did, you could go to youthful offender. And if you weren't successful, was it that same charge as what you're convicted of in criminal court?
To that effect. And I think it was 2009 to 2019, somewhere in there, where you had this conditional plea in criminal court. So you start in criminal court, you have the option to conditionally plea. So you basically plead to it, and then your case as a result would be transferred to youthful offender status. You comply with the conditions there. If it was revoked for a violation of the condition, you have already pled to the criminal charge, and so it can be returned to the criminal court that way. So that's how it was for about a decade in Vermont.
This is helpful. So, and then you're saying we got rid of that, which I can understand why there's negative pieces to that. And that you're saying now we're trying to piece things back together to try to adjust to that change that was made.
Yes, in light of the feedback that we've gotten basically originally from municipal law enforcement in the height of the pandemic, but then of the last 2 years from the practitioners, the social workers, and the deputy state's attorneys who are handling these cases. Yes.
And I just want to clarify that it is feedback. We don't have data specifically, because I know you mentioned the not engaging, or I think somebody else maybe on the aging out. Is there specific data on? Because I feel like if that is a goal that we're trying to achieve, it'd be helpful to know what is it now, so that if we do implement some of these things, we can see, are we making an impact?
Yeah. So it's an excellent question, and it's a question that came up kind of in a big way with Raise the Age last year when you're considering what to do there, of the paucity of data that we have regarding not so much the number of cases, but the kind of the outcomes of those cases. And one of the issues is how little data there is, other than some of just the numbers of filings. They have some of that, but there will seem to be very little data available regarding the outcomes and whether it was positive outcome, negative outcome, whether they aged appropriately or not. Anyway, so that's the logic, I think, for that first one, page 3, line 10. Page 6 places the burden on the youth to show that YO probation should not be revoked in certain circumstances. I agree that the key piece there is the burden shifting. That is, I think, worth focusing on more than anything else. I would note that under current law, 33 VSA 5285, the standard for the circumstances is in which YO probation should be revoked is very vague. So there may be an opportunity here to provide greater legislative clarity on the circumstances in which probation should be revoked or not. Right now, in 5285 subsection C, it says if the court finds after hearing that the youth has violated terms of probation, the court may maintain the youth status as a YO, revoke the youth status as a YO, transfer supervision to DOC. But there's no elaboration on what factors the court should be considering when doing that. I know in practice that some judges have used the original factors for YO determination to begin with as kind of a proxy analysis of what to do under that circumstance, if that makes sense.
Yeah, no, and so let me ask the question I asked Kim is rather than trying to figure out the lines in the sand, do we lay out, here's what you have to consider? And because there's going to be so many different situations, it's hard to really draw lines in the sand. So do you have a view on whether that's what we should be doing instead of trying to figure out the shells,
Yeah, I mean, one approach, and again, I'm just thinking of this in real time, and Judge Zone may have, thoughts about this eventually, is essentially cross-referencing the initial factors that the court considers on making the determination in the first place. Will public safety be protected? Some version of that, because you already have a whole framework, an analysis of for example, whether they're amenable to treatment, at the stage of revocation may be a relevant factor, because the court may find that continuing probation, whether it's DOC or still with DCF, well, if they're no longer amenable to treatment at that stage, that might be a relevant factor to consider.
Right. And actually, I could see in the revocation stage, if there's been violations, that at that point, this acknowledgement of harm can be even more important. If they're trying, I guess that's part of the amenability treatment, frankly. But all right, so anyway, yeah, we can consider that, and we'll take more testimony on that as well. But Coach, do you have a question? You're still muted.
Yes. Just a thought and something, I heard from Tucker, in his piece is, what can we legitimately, thinking in terms of the closed setting, of family court, actually extrapolate data? Because we'd want to know the effects of some of these changes. So what can we legitimately record, either from the judiciary side, DOC side, or DCF side? That's a general question.
And I think, through the past few years, DCF has been talking about their kind of data management system. I think there's been some shift towards maybe a new one. So they'll be able to speak better, I think, towards their goals in their kind of data management, data collection on what they're doing. And then, of course, what valuable data we can get from the judiciary on the topic generally. I do recall during our conversations of the past few years on Raise the Age that there was pretty limited data relating to the number of filings, and it was hard to glean much meaningful insight from that alone.
And that's been the case. I mean, because I'm thinking even pre-COVID times, when we were having these discussions about family court especially, and the implications of youthful offender, having data to support any differences in the applications, if that makes sense, Tucker.
It does. And, I should point out, and I try to point out every year, what makes this even harder is that these cases occur in a black box of confidentiality. So it's very challenging, I think, or with the lack of data and the lack of ability for you to kind of go down to the court yourself and to view these proceedings, or for the media to view these proceedings. So what I'm left with anyway is seeking feedback directly from the practitioners and kind of relying on their expertise on what they're seeing. And it's not ideal, but I do find that it's meaningful. And that's why I shared, the feedback that we did get, at least over the past few years, from some of those practitioners. Because like you, it's with the lack of quantitative data and the black box of confidentiality for all these proceedings and the overall complexity of these proceedings, it's quite a thing to be taking on as a public policy topic for the committee.
And maybe, we might need to give some thought, with our data partners, as to, how we might venture into that non-identifying identifiers, like education uses in some cases.
And again, I'll just defer to DCF on kind of like, I know they've been obviously grappling with the data collection over the past few years. So,
Yeah, thanks, Tucker.
All right, so on page 6, I don't know if you,
yeah, so that was what I just talked, page 6 with the burden on the youth, placing the burden on the youth. It's that burden shifting. And again, the main point there is looking at the existing standard is at a minimum, it doesn't provide a lot of direction or clarity on even what are the relevant factors that should be considered under that circumstance. So there's value, I think, in legislative attention, providing greater clarity. And I do think there's a role in potentially defining the circumstances in which the burden maybe should be on the youth to demonstrate why it should not be revoked. That's what you're kind of getting at in that provision. Whether it has to be that specific framework of active violence, I think there's a few ways to approach it. But there are circumstances there which I do think that burden shifting would be appropriate. Page 7 is revoking probation if the youth fails to appear at a probation revocation hearing. That was a specific issue with the state's attorneys and the problems that they've had there, and this broader issue of aging out, which is something that DCF has also previously identified, again, with a cohort of individuals who are doing these proceedings. And then page 8, clarifying that victims can attend motion hearings for YO status, not just a disposition hearing, expressing their views on the appropriateness of YO. I think there's a lot of value to engaging with that language and taking it seriously, because currently, language, to the extent it just is specific to disposition hearings, the train has kind of left the station at that point in my view, where there's a lot more thought that goes into the YO consideration hearing that we should be thinking about the victims at that stage, or there's a potential opportunity to.
go ahead, Zach.
Thanks, Jared. Thanks, Tucker. So one of the questions I have is in terms of the commissioner and more broadly DPS's view of what does a working definition of success look like for a youthful offender program? Is it? I mean, I guess I'll leave that to you. Is there a working definition that the department has?
Well, I'd say this. For the past few years, we've been talking a lot about accountability. That's been kind of a buzzword that we haven't kind of defined very well. And I think in our minds, there's this question of when we say that, or what we're really saying is, well, we're not always focused on rehabilitation. Sometimes we're focused on punitive response. And in my understanding, that is actually not what we mean when we talk about accountability in criminal justice public policy here in Vermont for the past few years. What I think it really means is that we have well-intentioned policies that are attempting to increase rehabilitation and decrease recidivism, but sometimes those policies result in a more permissive criminal justice response that actually undermines that rehabilitative goal. And that goal, that distinction there between whether you have a permissive criminal justice response or a rehabilitative criminal justice response is really where I think the public policy focus should be, and not on what I view as kind of a straw man, which is this distinction between a rehabilitative criminal justice response and a punitive. Because in the policy makers that I speak with, including Commissioner Morrison, that is not the focus there, or not the intuition, not the goal. It's really to make sure that when we talk about rehabilitation, we're actually getting that rehabilitation, and we're not undermining it through taking a kind of permissive approach.
That's really helpful. And I think one other question that I had is when we look at YOs, and again, I think the burden shifting is a really critical component in all this. And I know that we'll be taking more testimony on that and delving into it further. But when anecdotally, and I don't know if you have specific data about this, but when you look at youthful offenders that want to re-engage or engage in the program, do you get the sense that a majority of them want to be a part of this? How are they reacting in the program? Has it been successful in your view thus far?
I think it's successful for some. DCF uh, has that window into the probation supervision in a way that law enforcement doesn't. So I don't get that direct view as much. I do think that for those who don't want to voluntarily engage, it can be quite problematic. And my broader point is some of the procedural provisions themselves seem to like disincentivize
Participation.
meaningful engagement. And it's a hard age. I mean, this is not easy, I think, for anyone when you're dealing with teenagers of any age. It's hard to begin with. You do have sometimes folks who come in who do not have social supports. They have a high degree of oppositional defiance. And, that's a tricky situation for everyone. I think the courts, the prosecutor, DCF. It's not an easy for that cohort of cases.
Yeah, and my last one, I'm just curious if you have thoughts on this, is page 2 of 642, line 20, the youth's residential housing status. And again, I don't know if this would be for you or if it would be for a fellow witness, but I'm curious about, and this kind of goes to what you're talking about, is that supportive nature within the home. And, there are many different variations of the definition of family and what a nuclear family looks like and what a support structure looks like in the home. But if the individual is unhoused, how does that play into this? And again, I don't know if that's, I assume there's some of that in Rutland County, which is where I represent, but maybe there's more of it in Chittenden County, in Burlington. So I'm curious if you just maybe tease out how that could impact the success of a youthful offender in the program.
The distinction I would draw is that when you have older youth who are over 18, at that point, they don't have to legally be in school anymore. That's come and gone a while ago. They don't legally need to be in their parents' home anymore, and often they aren't. And so it's a different dynamic for DCF. I think, and I apologize, DCF, I don't mean to speak for them, but I think it presents a different dynamic for supervision generally when they don't have that obligation to be in school during the day. They don't have a legal guardian who is responsible for them at night. And so I think the burden on the state ultimately is higher for the older youth because they don't have any of those constructs that they can really impose. I mean, for a 15-year-old, I've had the barge, in diversion where they'll say, I'll pick you up and bring you to school tomorrow, and because you got to be there. I'm going to be there at 7:45, and legally they're obligated to get to that school anyway. So you have that greater level of engagement. Housing is a piece of it, but I think it's that broader network of supports. And to be clear, YO is up to age 22, right? So 18 to 22, you have this 4-year period where people can be in a pretty precarious situation. And all we have is this YO structure to say we really need you to meaningfully engage.
So do you think there needs to be different stipulations for that bracket of 18-22 to qualify for youthful offender protections? Or you wouldn't want to go so far as to advocate for that here?
Well, we have that to a degree.
Yeah.
There's so many kind of carve outs, right? I think the key takeaway is to keep in mind with YO that we don't necessarily have all of those social supports that are going to result in the positive outcome. So you do have to have the meaningful guardrails to say, hey, look, this is an opportunity. You can lose the opportunity. In certain circumstances, this isn't a joke.
Thank you. All right, great. Thank you, Tucker. And we'll go to Matt Valerio will be our last witness on this today. And the folks I didn't get to, and I apologize, we'll be scheduling more time on Friday afternoon, and you will hear from Nate. But Matt, if you could join us, thank you for being here. I think people will leave around 15:15. Yes, and if we need to have you testify further on this, we'll find another time as well. I'm sure that there'll be another version that you'll need to weigh in on, so.
Matt Valerio, Defender General. I guess fundamentally, before we get into anything, just give you the overarching opinion of this bill from my department is that nobody likes it. They don't like any of it. And it, I think part of this starts with why. You know, you hear about anecdotes, you hear about lack of data. I have a review that was done by the Crime Research Group, the people who come in here routinely. They did a review of the youthful offender statute and the number of people who were in it. They produced a spreadsheet that did a snapshot. Over a 2-year period, there were 98 unique individuals who had a finding of youthful offender in family court. 19 of those youths over that 2-year period earned a subsequent criminal conviction in adult court for an offense after the finding of youthful offender. 10 of those committed were in the first year, 16 within 2 years. The 1-year recidivism rate was 10%. 2-year recidivism rate, easy for me to say, was 16%. You know what the recidivism rate is like in adult court? It's almost 60%, right? The bottom line is the youthful offender system as it currently exists, at least during this snapshot, now this could easily be updated, is 40% lower than an adult court. Now, if
What's the date on that?
this was September of 25, September 16th. You want it? There's a spreadsheet that attaches, but I didn't want to print all of that out. Some of the concerns you hear about this is the people in youthful offender aren't doing what we want them to do. If the concern is that youth don't always do what we want them to do, all right. If the concern is we don't want you committing new crimes after you're in youthful offender, well, then youthful offender is being successful overall. This is under the new program. Now, you might have particular recalcitrant individuals who are going to annoy the hell out of local law enforcement because they run into them every day and they find out that they're on youthful offender, and that gives rise to why isn't youthful offender working? When you look at it as a whole, youthful offender is working, all right? But as a practical matter, when we drive things by anecdote and by a lack of, I think, realistic expectations, because I don't have a lot of faith that, anybody who's a youth is going to do what I want them to do. But I'd be satisfied if they just don't commit any crimes. And that's what we're trying to do here. Now, what does some of these other words that we use about, rehabilitation and accountability and however we define those things, to me, if somebody can go through their life and not be charged with crimes, that's a good thing. I always said that there were a couple of things that I wanted all my 4 kids to do is to not get arrested before they were 21 years old, graduate from high school, and then I had a third unrealistic expectation that they all graduate from college within 4 years and not cost me extra money. Luckily, they did all of those things and even the unrealistic one. Bottom line was, it's not easy actually to go through your youthful years without having some sort of indiscretion and get caught, and they luckily did not. Crap. I have to grab my glasses because I can't read this stuff if I don't. Sorry about that. I have them right there. Much better. I'm going to speak generally about the provisions of section 1, section 2 of the bill and some of the overall concerns that we have. In general, section 1 kind of gets at the point of you can only get youthful offender effectively if you admit that you're guilty. And youthful offender status is not, it's different than other statuses. It's not like diversion. It's not an alternative justice program. It tends to be for high risk, high need youth facing criminal charges in adult court. It provides a way for them to access juvenile resources through the supervision of DCF. But it doesn't eliminate the risk of criminal punishment. This is as the law exists now. They are still facing the possibility of sentencing for an adult charge if they admit or ultimately are found guilty. The immunization, which is what we're really talking about, of that provision in section 1 is something obviously that, you know, is a trigger for defense counsel. Like, why would you ever have your client do that? The key is that if they are amenable to the program, it doesn't matter if they admit to specific acts. So if you are requiring that they admit before ever allowing them to go to youthful offender status, it means that a lot of the kids who most deserve a chance in a juvenile setting, those, and some of those may not be guilty at all, will admit to something they didn't do so they could get access to youthful offender status. And as written, the bill proposes to make things easier for the kids who are the most culpable because they'll just accept, and disadvantage to the kids who are least culpable because they'll admit even though they didn't do it or they didn't do exactly what was charged. Part of the overarching thing in this bill is there's an assumption that everybody who's accused of something is guilty of what they're accused of, which couldn't be further from the truth. Another way of looking at this in section 1 is it's based on the assumption, and again, I just kind of said this, is that whenever there is an allegation of a violation of the conditions, or if there is an allegation of a crime, that they're automatically guilty of whatever it is they were alleged to do. The way this is written, it's basically saying that you can't have youthful offender status if you don't admit to something, no matter what's alleged. Historically, the youthful offender system that was discussed by Tucker earlier it wasn't used that during that 10-year period that was being discussed. It was basically, on average, our stats show that it was used between 14 and 30 times a year, and only in a few counties, and primarily it was used in Bennington because Senator Sears was a big proponent of youthful offender, and he was kind of on the butt of the state's attorney down there to say, you know, could we get some people into youthful offender? The change that eliminated the conditional plea concept made it so that people were willing to actually use the system, and it eliminated the requirement of an admission of guilt. If you go back to the old way, and right now we have hundreds of people who access over a period of time youthful offender. My guess is we're going to go back to a couple of dozen people a year accessing the system. Much of what's in the bill is already considered by courts in making determinations about whether you're good for youthful offender, whether you're not good for youthful offender, whether you violated a condition, because every single person who is on youthful offender status has conditions of probation, not to commit any new offenses, not to commit any violent offenses. And if a violation is brought, violent or not, the judge can and almost always will, particularly in the case of a violent offense, revoke the probation. Our experience is that they haven't seen many cases where someone gets to stay on youthful offender probation in the face of a violation for committing a new serious offense, and certainly not a violent offense. The provision says that the court can revoke probation for commission of a violent offense as it currently sits. And they already can, and they do, but only if the kid can prove that public safety can be protected. That's the change, shifting the burden. So currently, if a judge decides to revoke for commission of a new violent offense, which they almost always do, the kid has no recourse. And that is judicial discretion. The provision as proposed would limit the discretion where there's not a problem. And if there are particular instances where it is not revoked, it's extraordinarily rare, and there's a reason for it. I think this seeks to fix something that's not broken. And so I don't really know where it's coming from, right? Because I don't think that people on the ground are seeing that as being the issue. There's another part in section 2. Somehow attendance has become like a big issue. But it targets the wrong people. So the portion in section 2 that says that if a youth fails to attend a hearing, their status shall be revoked. Youth fail to attend hearings more often because they don't have adults who they can rely on in their life to make sure that they get there. You want it in a situation where you have a 16-year-old kid who's struggling to make it through the youthful offender status and avoid jail, but they end up, they have a parent who has their own issues. Maybe they're drug addicted, maybe they have mental illness issues, but they aren't going to be there to give them a ride to court. That's what happens oftentimes when kids miss hearings. They're relying on people around them, and those people are not the kind of people you can rely on to assist you. This is a situation where effectively we're kind of punishing the kids who are in the worst situations and rewarding the kids who have the most resources and supports. Weirdly, this wouldn't affect some of the more serious offenders, people who are in youthful offender but still have the most serious charges. Those youth who have the most serious charges tend to be in DCF custody. And those kids are never responsible for getting themselves to court. DCF is in charge of getting them to court. And oftentimes DCF is not able to do that. They can't arrange transport, so the kids miss hearings when they're in custody, and as written, that could be held against them. So this provision targets kids who are not such serious offenders that they're in DCF custody, but who are trying to manage the youthful offender probation while living with people who might not be reliable or with the supports that they need to help them get to court. And at the same time, the kids who are the more serious youthful offenders who are in DCF custody don't have that same responsibility. It's kind of odd. I'm very supportive of victims, and I'm talking about Section 3 now. I'm very supportive of victims having as much knowledge about what goes on in a legal proceeding that involves something that had involved them as possible. There are times, however, when the elements that are considered by the court to make decisions cannot be commented on relevantly by victims. Making a decision, let's assume I mean, you have someone going into a youthful offender hearing, having a victim impact statement before they're ever adjudicated doesn't seem to make any sense to me. It makes sense when it comes to the disposition side, but whether somebody's amenable to youthful offender. Yeah.
Do you mind if I interrupt you?
Yes, sure.
Are you sure? I just want to clarify, because trying to follow all the youthful offender, like where things are at and which part we're talking about. So are you talking about the determination that the court's making in this bill? It's on page 2, determining whether public safety will be protected by treating youth as a youthful offender. The plain witness. So I understand the section you're talking about is Section 3 as far as who's being heard, but is the process in which they're being heard in, is that the determining the public safety will be protected by treating the youth as a youthful offender?
Right.
So
isn't that part of what the screening tool is doing? Like, that's a professional determination by DCF. I don't know how. Leaving a lot of that going.
Yes.
That seems to me to be a professional determination about risk that is part of what the DCF does in screening. I would not expect that most victims would feel great about the fact that maybe even the case is being considered for youthful offender. I don't know. I mean, not everybody's that way. There's all kinds of people, and I can't universalize. But whether a particular individual is amenable to youthful offender seems to me to be a professional determination from a risk, needs, and psychological standpoint, as opposed to something that a victim would be competent to testify about. Like, that evidence is not relevant. Like, what they could provide is not necessarily relevant. It would make them feel better, perhaps, but I don't know that it'd be relevant to what the court has to find when making a determination as to whether somebody is amenable to youthful offender treatment. And you got to remember, depending on how this all turns out, this could be before there's any determination that anybody's guilty of anything. I think the whole concept, and I know what Dick Sears was trying to get at with this, is it's not particularly relevant what the specifics of any particular event are that brings this person to the justice system. They may have committed a criminal or delinquent act. They may not have. It may not be exactly what was alleged. But if we identify the people who are in need of intervention, we can help them and then make sure that, or try to make sure that they don't commit new crimes going forward. If we can keep them out of the justice system when they're young, then we won't have to deal with them when they're old. That's what the point was. And so, to me, I agree with that vision, and I'm trying to make sure that that is preserved. What I see the bill doing is unraveling what good came out of ultimately getting us to the point of the youthful offender statute and process that we see now. And really going back to the old way of doing things, which people just did not take advantage of because it wasn't in the interest of their clients to do it. So now I haven't had the chance to take a look at the other bill. I know it's like 60 pages or something. So I was looking at what we had here and trying to balance that with 10 other things. But happy to come back and talk about whatever that says. It's just, there's a lot in it. That's all.
Karen.
Yes, so on this piece of involving the victim, I appreciate you pointing out how very different when it's a point of disposition, like after that's already been established, versus at this point, it hasn't even been determined the person did anything, or that this is the victim of what actually happened. None of that is, and they're not questioned at all. So they're able to just put something out as fact that can then influence the fate of the other person. Is this correct in how I'm seeing
Right.
it?
And it might, honestly, if it ends up coming down to ultimately a hearing, a trial on whether or not this occurred by court, the victim can say whatever they want to say and that might not be even competent evidence, but now that evidence is before the judge, before we ever get to the point of having to come back and make a determination about whether or not something ever happened if there's a violation. So it sort of pollutes the process. And like I said, I have some empathy for what the victims go through in these cases. And over the years, and I think I've told you folks this before, I've represented victims in civil cases against, this is way before I was a defendant attorney, but against, perpetrators of all kinds of crimes. There's a frustration because they don't know what's going on. Like that's the biggest, as far as I can tell, they don't know what's going on. Some don't want to tell the story. Some want to tell the story as many times as they can tell it. And disposition is not enough, and they want to tell it at the YO determination stage. What drives any particular individual is, I'm not exactly sure, but I don't discount it. What I'm trying to do is to keep the process so that the elements that have to be proved for youthful offender to make the determination of whether they qualify, those seem to be, to me, separate apart from what relevant evidence a victim could provide at that stage. And again, I don't have any problem with them getting full information about what was going on at that stage, but I don't think it's the place for them to testify. I don't think it'd be, if you were having that contested hearing, there's not an element that is relevant that they would testify about.
One clarifying question. You said you don't want to see it go back to the old way, which would kind of defeat the spirit of what
the conditional plea
is. It's a conditional plea. That's the old way.
Right.
And so this is your position is the current proposal.
It's why people didn't use it.
Yeah, because they basically were like, we're never. Yeah. Do you think that if you added in the kind of language that Kim suggested, that would be enough to safeguard it?
You mean immunizing the admission?
Yeah. And you talked about this already.
Yeah, I don't think so. I mean, that would solve that problem if this went forward, but if you created a system that requires a conditional plea, then you aren't going to see people use it.
Yeah.
So perhaps one last question, there'll probably be more on a different date, but this concept or concern that in part is driving this is individuals finding out and not having been rehabilitated, not having done the programming. Is there a way to address that?
If that's the question you want to answer, I guess, you know, that's something to look at. To me, I come back to that original question. Are we concerned about people doing what we tell them to do, or are we concerned about people committing new crimes? If they're not committing new crimes as a result of whatever participation they have in this, and then they age out, do we really care? As opposed to, are they just not doing everything we tell them to do? And I kind of opt for the thing about, I don't believe that most people would find it easy to comply with even like conditions of release. Even law-abiding people have difficulty doing that. But, conditions of youthful offender probation do tend to be pretty detailed, and they require some work. It doesn't surprise me that not everybody complies. But if the data is showing us that they aren't committing new crimes, then I think we've succeeded.
But if there's a situation where there's been cause to revoke the youthful offender status and the person's just ducking the hearing, then they have to be there.
You mean cause, you mean allegations, or has there been like a new conviction?
There's been probation violation, could be a new charge, could be. But there's a ratification here.
Approved probation violation as opposed to an alleged probation violation.
So how do they have to have the youthful offender in court to have the case approve the violation?
Yeah, you think?
Yeah, you think? I mean, can there be an arrest warrant of some sort to get the youth into court? All right. Well, there's some things to look at, and we'll have another draft and seek your input.
There's one thing you can be sure of: there's always another draft.
There's not many things in life we can be sure of, but there will be another draft.
I was in house corrections and institutions before I came here, and they had posted the thing that they wanted us to talk about online. They posted it online. I pull it out, I read it, I'm getting ready to do it. And then we're sitting there, I asked him, like, oh, we have another draft. What?
We'll try not to do that.
Well,
I have done that before.
yeah, I know.
But we're adjourned until tomorrow at 9 o'clock. We'll go offline.